Okay, welcome to the May 12th Rent Leveling Board hearing. I'm going to begin with the statement of compliance. Notice of this meeting was given to the township clerk and posted on the township bulletin board and the township website calendar, and sent to the West Orange Chronicle and Star Ledger. This meeting has been properly noticed to the public in accordance with the Open Public Meetings Act. No new matters will start after 8 p.m. Okay, so let's move on to the Pledge of Allegiance. Will everyone stand for the Pledge of Allegiance? I pledge allegiance
to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Okie dokie. Let's move on to.
Excuse me, Madam Chair, just want to interrupt 1 second. I just spoke to our newest board member. Apparently there was an issue with the email. He's going to be joining us in a few moments. So I just want to let you know that he is going to be joining us. So, and just when he pops in, I'll let you know.
Okay, thank you, Peter. I appreciate it because I was getting ready to announce him. All right, so let's move on.
Actually, Madam Chair, he's actually here. There's
Paul Pettigrew. Okay.
Hi, Paul. Welcome.
I wish I could see everybody, but you know, you can't always get what you want. So I'm going to proceed with my announcements, and I'll start with the fact that our next scheduled meeting is taking place on June 9th at 6 p.m. in person at Town Hall. That's pretty exciting. My second announcement is to introduce Councilwoman Michelle Castellino's appointment to our board, Mr. Paul, how do I say it, Pettigrew or Pettigrew?
Pettigrew.
Aha. What I do know is that you are a practicing real estate attorney. And Paul, if you'd like to share a bit of information about yourself, would be lovely.
Okay, well, I served on the school board here for 12 years before I retired. And I also was president for 3 of those years. I'm also on the budget advisory committee for the town. I've been on that for the last couple of years. I practice law right now in between West Orange and my other offices in Colts Neck, New Jersey. And I've been a resident of this town forever. It seems like forever anyway. But for I don't even remember. My kid was in second grade. He's now 32 years old, my oldest son. So okay. I guess so I've been around for a little while.
Okay, thank you. Welcome to the board. I also wanted to share in my announcements that we had 2 members of our board who were unfortunately unable to join us on the meeting that took place on April 12th. But what we do have in our possession are affidavits for Vice Chair Anthony Campagna and Board Member Rodolfo Rodriguez, confirming that they have reviewed the videotapes of our April 12th meeting, and they're prepared to participate in our deliberation. I think that's all for my announcements. Peter, you're welcome to start the roll call.
Okay, 1 second, I apologize. It is roll call. We have Board Member Rodolfo Rodriguez.
Present.
Board Member Paul Pettigrew.
Present.
Board Member Kabira Myers.
Present.
Board Member Asmer Gemmermichael.
Present.
Board Member Melinda Huerta.
Present.
Vice Chair Anthony Campagna.
Present.
And Chair of the Board Deirdre Post Sanders.
Present.
Madam Chair, you have a full quorum. Enjoy your meeting.
That is absolutely wonderful. Okay, so as we know, we have one application before us, which we will be deliberating upon, and that'll be the matter of 91 Ashland Avenue LLC. However, before we begin, I did have a few questions that I did want to pose to Alex, Attorney Graziano. So the first question was, we have a new board member, and he, of course, has not participated in any of the earlier meetings, any of the previous meetings. So what role can our new board member play this evening with respect to this deliberation, Alex?
Madam Chairwoman, it's my opinion that Mr. Pettigrew can participate in all aspects of the meeting except for voting on the final decision. Since he wasn't here for the hearings as they proceeded to date, he doesn't have the same background as the other board members. So my opinion is everything but voting. He has to abstain from voting.
Okay, all right. And then my next question had to do with guidance with respect to our deliberation. We know that, how do I articulate it? We know that there is an increase in rent that is desired, and we know that someone prefers not to have their rent increased. So I want to know, do we have any leverage, any leeway in what kind of increase we may desire, or what, or is it black and white? Is it either you increase it to the number that's requested or not at all? Or is there some middle area that we're allowed to decide upon?
Madam Chairwoman, I've researched the township ordinance on this, and there is no provision in the ordinance that says that it has to be a straight up or down, yes or no kind of a decision by the board. So the board is free to either grant the application, the requested increase in full, deny any increase, or approve of an increase that falls somewhere between 0 and what the petitioner is looking for.
Okay. Okay, well then, with that being the case, I think we can open the floor to public comment. And Mr. Graziano, I might need some direction here. At this part of the hearing, is it just when everyone makes their last case, or do we just go right into deliberation?
Madam Chairwoman, the petitioners and the objectors have presented their cases in total. So the only thing we have before us tonight is discussion amongst the members of the board, Mr. Pettigrew included, if he wants to participate in the discussion, but as I said before, can't vote. And I would suggest to you that we just hear from the board members in turn as to what their thoughts are regarding the application, and where they might feel that the decision should go.
Okay.
And then once we reach a point where everyone has spoken his or her piece or made his or her observations, then we can have a motion and a vote.
Okay. So then I'll open the floor to the board. Would anyone like to get the dialogue going with respect to opinions on the matter?
I do.
Excellent.
Well, I believe that, we have to put in the owner's shoes. We pay really high taxes here in West Orange, almost everywhere. We don't have in town an apartment with 2 bedrooms for $800. You can't find that anywhere. There's no way that a landlord can pay taxes, expenses, fixing and all that with $800. If that was the case, I'd rather do that than paying my mortgage. I mean, if I'm gonna get something for $800. I think I was reviewing the whole thing. I think the landlord is not asking, he's not asking something out of this word, because even in East Orange, a 2-bedroom apartment is paying like $2,500. The man is asking, I believe it's like $1,400-1,500. I think it's fair what he's asking, because I mean, in all fairness to him, taxes, expenses, there's an investment there. I mean, come on. And these tenants, they have a month-to-month lease. It's not even a long-term lease, none of that. And I think what he's requesting is fair. Because then, you know, what we're doing, I mean, just let's put ourselves in his shoes. If we had an investment of, I don't know how much money he paid for that building, and he had to pay the high taxes that we have in town and all that, expenses, water, fixing and all that for $800, I mean, less than $900, I don't think it's fair to him. And what he's asking, I don't think is out of this word, because I would not. I mean, if that was the case, I would rent rather than paying paying mortgage and all that for $800. So I think he's asking fair for, I think it's $1,500 or so that he's asking for a 2-bedroom.
Okay, thank you. Thank you. Would anyone else like to comment?
Yes.
There's several hands up.
Yeah, there's actually several hands up, and I think Asmaret was before me, so.
No, it was Melinda, then you, then me.
Got you.
Thank you.
I'd rather go last. So go ahead, everyone.
Okay.
I'll put my hand down and wait till everyone speaks.
Okay.
All right, so if I may, I think that it's extremely important that we do not take sides on this. To say it's not fair to the landlord is advocating for the landlord. And that is absolutely not our role. And I think that it is inappropriate to be taking sides. You know, our objective and our, you know, requirement and responsibility as board members is to look at the application before us in its 4 corners and apply the law accordingly. So if the law says we can or cannot grant an increase because of X, Y, and Z reason, then that is what we must do. But to take a side is prejudicial, and we absolutely cannot do that. All right, so I want to start off with that. You know, even though I'm a tenant defense attorney, I'm not going to, you know, come on this board being a tenant advocate, because that's irresponsible and inappropriate for me to do that. Now, here's my concern with this application. I feel that, yes, this landlord, this applicant should get some type of increase. The problem that I am having, though, is that the ordinance is clear that if the landlord has not shown demonstrable compliance with the requirements of the ordinance, then no increase is allowed. That is indicated in multiple places throughout Chapter 15, which is our rent control ordinance. And I've seen multiple violations of the ordinance by this applicant. For example, he increased the rent without giving the tenants prior notice. He conceded to that fact on more than one occasion. I am of the position that, one, the tenants should be reimbursed that those unlawful increases, you know, whatever excess they were paying in violation of not just the ordinance, you know, municipal law, but also state law, because state law also requires written notice prior to the increase of the rent, right? So the ordinance also makes it clear that state law must be complied with, right? So before I even feel comfortable granting any sort of increase, whether it's the entire thing, whether it's 10 cents, I want to see these tenants get reimbursed. And since I want to see these tenants get reimbursed, and since I want to see these tenants get reimbursed The agenda analyst person needs to be muted. I don't know how to do that. Yeah, that was really weird. Okay. So that's my preliminary take on this application. That I think that the landlord should be granted an increase, but only after there's demonstrable compliance with our rent control ordinance. And in my opinion, that will start with giving the tenants back that excess rent that they were not required to pay under the law, and that violated the rent control ordinance. Thanks.
Who's next?
Hi, it's Asmarat.
Hi,
So
Asmarat.
honestly, I agree with Kabira. We shouldn't be taking sides. We should just answer based on the facts that are given to us and following the ordinance. But I do believe that the landlord does have a hardship case. On our West Orange website, if you go under the public housing agency for section 8, 2 bedrooms, it's $1,730. So with that being said, I do believe he has a hardship case, and you can't even find 1 bedrooms for, the 800, 900, which is, a fact in West Orange right now. So based on the market, 2 bedrooms, I think that he is asking something that's reasonable and that's fair. So that's where I land with that.
Thank you. Anyone else?
Paul had his hand up. I don't know if it's
Paul?
or did you?
It was an accident. My computer went kafooey on me. I lost the sound and everything, so I had to turn it off and turn it back on again.
Okay, so then
I just want to make it clear. I'm not taking any side. Like the last speaker said, the last board member said, you can't find for $1,700, $1,800 an apartment out there. What I believe is like what he's asking is reasonable. And then, this town, we don't have too many people paying $10,000 a year on taxes. That's a building. I don't know how much exactly he's paying, but it's just not a matter of side or whatever, taking side or all that. It's just fair for both sides. I mean, I know people that they paying $2,000 in East Orange. This is West Orange. I mean, this is what I mean. It's not about taking side, defending or going in one way or the other. It's just what's fair for both.
Thank you for clarifying, Deputy Mayor.
Thank you.
I think Belinda had her hand up.
Yep.
But she wanted to go last. Anthony has.
I want to go last, so go ahead,
Oh.
Anthony.
Yeah.
Thanks. So I tend to agree with a lot of the points that everyone's brought up so far. With regard to what you just mentioned, Rodolfo, the fairness aspect goes to a bit what Board Member Myers was talking about. Fair or not, our job is to objectively interpret this ordinance and apply it to the, our best judgment of its law. And because of the way it's written, while these rents are clearly under market, we can all come to an agreement on that point. There is this ordinance in place that protects the tenant's rights to increasing the rent at certain percentage points. So I'm also of the opinion, like Kabira, that I do think there is a justified increase. I just want to kind of stay out of this is fair, this is not fair, and much more into let's interpret the facts that have been presented to us and then use them in conjunction with the ordinance to come up with our judgment.
Thank you. Thank you. Anyone else? I think, Melinda, I think you have the floor.
Well, Deirdre, you're also a board member, although you are the chair.
I know. I do have some thoughts. First of all, I just want to, we all know that the institution of this board, it hasn't even been in existence, and it's been in existence, but there hasn't been in practice since, if I'm not mistaken, was it the 1970s? What does anyone recall? I mean, this is our first
It's-
meeting in a great while. So with that being said, we as a board are just learning how to function. I don't know how a landlord would know whether or not he was in compliance with the ordinance one way or the other, because it almost seems like it was something that existed but was not actually implemented. Now, I could be mistaken there, but that's what I've gleaned from all the meetings we've had thus far. I don't think anyone can even recall when the rent leveling board gathered to discuss such issues. So if we as a board, there's a lot of things we didn't know as a board functioning. I don't see how a landlord could be expected to understand what their expectations were with respect to the ordinance and being in compliance with it or not being in compliance with it. So my opinion is, yeah, I definitely think that an increase should be granted, but in terms of being in or out of compliance, I really don't think it's fair, because I would suspect that many landlords in this town don't even know about the ordinance and what is required to be in compliance with respect to the ordinance.
So
That's
if
all.
I could, if I could just say something without stepping on anyone's toes that might have had their hand up before me, let me know. All right, so Mr. Graziano will appreciate this. One of the things that we attorneys say all the time is that ignorance of the law is not a defense. Before this applicant filed this application, it behooved them to make sure that he understood what the law was. And even after he filed his first application, we gave him, as I mentioned earlier, multiple bites at the apple to get it right. It was almost as if we held his hand. So even after that, you know,
as we should have.
No, we're not obligated to handhold an applicant. We're not obligated as board members to hold an applicant's hand. The obligation is for the applicant to make sure that they understand what the requirements are and to reach out to the rent leveling board off record if necessary to get the necessary information needed. That is something that the rent leveling board can do, you know, outside of a hearing, outside of, you know, of an application. The ordinance is clear, you know, that board members can provide guidance on compliance with the ordinance. To my knowledge, that was not done until after applicant filed his application. And here's the other thing. If you're going into the business of you know, increasing rent and becoming a landlord, there's also state law requirements as well. Applicant is well aware of that. You know, he's, I understand, well-versed in real estate law. So I just do not want to start saying things like, well, because he didn't understand the law, we need to give him deference. I mean, if we start going down that slippery slope, then we might as well give deference to everyone and ignore the existence of an ordinance. The ordinance is in existence for a reason.
I do want to say this. I do want to say one thing. We are not.
I'm sorry. My hand is up.
Sorry, I can't see
I was next. It's okay. That's why I interjected.
Well,
I agree with you, Deidre. We are new to this board, right? Newly revamped. But I agree with Kabira in this matter. We did tell him that the ordinance is available online, and in one meeting where he could have went on there and looked at it, which is the truth. We can go back to those Zooms, they're all recorded. While I agree he does have a hardship case and I feel like he should get the increase, we did give him an opportunity. Kabir is absolutely correct, because we had, I don't remember, I think it was the first one, right? When we had to postpone because
yeah, it was the February meeting. Yeah.
Yes, we told him everything's on the website, the ordinance is on there, anyone can get access to it. So while other landlords may not know about it, he was aware and did know about it.
this is true. I do want to clarify though.
I just want to be fair and make sure, you know.
Yes, I do want to clarify that that is definitely what we're not voting on tonight. So this may be this is a fact. It's recorded, but we're going to focus on the task at hand, which is whether or not this landlord is entitled to an increase or not.
So, and if I may, another thing, my concern, is that if we, move forward with this increase, when the ordinance is clear that compliance is a prerequisite to any sort of increase, then I think that that's an appealable decision. And as I mentioned before, I'm not trying to have somebody file some, grievance with my name attached to it, or even the rent leveling board's name attached to it, whether it's in the Superior Court or with the township, municipal, council, township council. That is an expenditure, and an exercise in time that I just don't want to have to be involved in. So.
Well, may I propose, I can't see the hand, so I apologize if someone has their hand raised. We could possibly, to rectify that, there could possibly be a penalty for that not having taken place, and then move on with our increase, in my opinion. It
Can we
doesn't
do
have
that,
to be
Mr.
like-
Graziano? Is that something that we can do? Can we move ahead and have him, I guess, pay back the difference
Yes, you have the power to
versus
order that.
postponing it? Okay,
If the board decides to do that, you have the power to do that.
I think that's a great alternative, Deidre.
That's right.
And if I may add to that proposal, that instead of imposing the entire increase in one large, chunk, due to the fact that there are tenants who, who objected and indicated that they're experiencing financial hardship, perhaps we can do it in increments. That's I've seen that happen before. Other, rent control boards have done that in the state of New Jersey. They've granted the increase, but not all at one time for every apartment. Thanks.
I think as a board, we have to think about that. We'll continue the dialogue. Anyone else have anything to say now? Are we at the lovely Melinda?
Melinda has her hand up. I know you can't see, so I'll help.
Thank you so much.
You're welcome.
I really appreciate it.
Thanks. Asmar, did you have something else to say? Because
No,
I kind of want to observe a
removed my
little.
hand.
Okay.
I was just letting
All
her
right.
know that you had your hand up because she can't see.
I don't know why.
Right.
It's okay.
Yeah, it's okay. No worries. So I do agree with a lot of the things that are being said, in particular, to make sure that we're going off of the ordinance. That's why we're here, right? We have been looking at this ordinance since 2021. And even though we have not made any amendments, we have not made any recommendations to the town council, that is a part of my frustration with, the work that needs to be done. And the reason that it hasn't gotten done is a number of reasons that we won't go into at this moment, right? My concern is that it does not, as it currently stands, the applicant doesn't comply with the ordinance. And as Kabira has mentioned before, doesn't even comply with the New Jersey rent withholding. What is it? I'm so sorry. I had my notes
New Jersey law.
Right, New Jersey law. So there were several inconsistencies. He did know, the applicant did know that this ordinance existed when he purchased the property. This is something I did ask during the questioning. I do believe that even the owner, who was the previous owner of the building, also knew about this ordinance and was also in compliance with the ordinance, which is why the price of the building or the rent that the tenants were paying is so low, because this particular landlord that owned the building before was complacent with the ordinance. So that means that he did know, he was aware of the ordinance and its existence, because testimony from the objectors say that the landlord did raise annually the 2%. More or less, I think that's what the math came out to. And so he was in compliance with the ordinance. I'm not disagreeing that he might be eligible to be eligible to have a hardship increase. But as it stands now, this application, and it just doesn't comply with our ordinance. And he was well aware, the applicant was well aware that the ordinance existed prior to purchasing the building, which was, I think, also a part of why he was able to purchase the property at a very low rate, which is what he said, was a great, investment, I guess, on his part, he thought. And that's just something that he has to, that has to be taken into consideration. He was aware of the ordinance, which is why he was able to reach out to us and he was able to submit an application.
Are there any other comments from the board?
Yeah, I'll just respond, or I guess ask questions to board member Huerta about that. I don't know that we should be considering what the previous owner was or wasn't in compliance with. And I also don't think we can assume that he was only raising the rent at a certain percentage. And that math absolutely does not check out. 1991 when the leases weren't, anyway. But I agree with the main point of your discussion that being out of compliance means, there's a challenge to our ability to bring this forward. I just want to really remove anything with the previous owner or reasons for purchasing the building. That's not what we're here to discuss.
I second what Anthony says.
I agree.
I agree. Okay, so where does this leave us? I honestly feel that there are two separate issues here because we're all seemingly in agreement that there is some kind of hardship here and that a rent increase could make sense. So, as I stated earlier, I would challenge us to look at it as two separate topics, and maybe there could be a penalty associated with the non-compliance and a rent increase, separate and apart. So can we, could we possibly vote on these two items?
Yeah, Asmeret's got her hand up real quick. Yeah.
Yes.
Thank you. Can we go in executive session with just the board members and our attorney, Mr. Graziano, to discuss this without members of the general public, or is that not allowed?
We can only go into executive session, Ms. Gebra Michael, if we are discussing matters that are protected by attorney-client confidentiality. In other words, if I was giving you legal advice or we were discussing, well, we're not the mayor, we're not the township council, but if we were discussing personnel matters or salaries or things like that, otherwise we have to do it here on the record in public.
Okay, thank you for explaining.
Okay, so.
I'm so sorry. So
Yes.
Attorney Graziano, if we did ask for your advice on a particular matter, can we go off the record and get that advice from you, or must we still?
Yes,
continue
if you're asking me for my legal advice, yes. I've been up until now, I've been giving my legal advice on the record. I don't think we've gone into executive session at all since I've joined you here. But if you do want to do that and you want to limit, and we want to put on the record that we are discussing matters protected by the attorney-client privilege, then yes, we can go into an executive session. If we're going to just deliberate off the record, we can't do that.
Yeah, no, can
We
we
have to
do
it on
that?
the record.
I feel like we all have questions we want to ask you, right, Kabira? Like there's some questions I want to ask him, and
Well, I'm actually pretty clear, but no, if you want to do that, I'm totally fine with us going off the record to get legal advice.
Everybody, you need to understand that in Zoom, that people are considered panelists, so you can't really go into executive session on Zoom. You'd have to convene a conference call outside of that, because we have applicants and me that would be listening in, and the tenants representative. So what I've seen other boards do when they go into executive session, I put Zoom on hold in a short break and pump nice music into the record, and you you all get on a conference call and ask your questions to council. That's my.
Could we create a separate Zoom link that we can all log on to? Since we're all already on Zoom. I just have a feeling that the conference call is gonna make everything a bit hectic, like a call, an actual call.
I did too.
Or Megan, could we, I know with, when I've appeared in municipal court, you know, talking to the prosecutor, they put us in a separate room in Zoom.
Breakout room.
A breakout room. Is it possible to do that? Because that's not part of the record and that's not part of the public.
Yeah,
you know,
we
I'm
don't.
just talking.
We don't have breakout rooms within this model of Zoom webinar that we have. I know there were some updates, but I didn't see anything about breakout rooms. I'm looking. I can create a different link. Mr. Smeraldo, do we have to notice executive session?
You didn't have any
What are
notice.
the repercussions if we just ask our questions? I mean, what I want to know is,
a public question. It's a public
on this matter without, I guess, legal issues, because Kabira brought up what could happen possibly, right, from the tenant perspective, because he didn't follow the ordinance. So are there legal repercussions to us if we were to vote on this? Like, that's my question. Are we able to come up with the decision for hardship and then, you know, impose some kind of fine or ask him to pay back the increased rent?
All of those things are within your power as a board, Ms. Geber-Michael.
Okay, thank you. Then I'm good. We don't need to go into executive session.
Absolutely. So can we at least take a vote on item 1, the issue at hand, which would be the imposing of the rent increase?
So my only question with that is maybe there needs to be a part B to that, because okay, because I was going to say some folks might not want the entire thing to.
Right.
Yeah.
I'm not clear on what. Yeah, I'm not clear on what exactly. I don't see that on the agenda. So I just see the application. So I don't see anything underneath the application.
Well, what the purpose of this meeting was to deliberate and decide upon a plan of action. I mean,
okay,
that's the only reason we're meeting this evening, was to take a vote on whether we were going to impose a rent increase or not. And I've learned that we have the flexibility to decide how much of an increase. And now, since another topic was brought up regarding compliance, the part B would have been voting on what we think is an appropriate penalty for the non-compliance. So that's the B. The A is just yes or no. Are we allowing this landlord to raise this rent? And then B would be, okay, so what kind of penalty are we going to impose for the non-compliance?
Yeah, can I just clarify something with Kabira? One of the things you mentioned before was potentially like spreading it out over a couple of years. In that scenario, would you be comfortable if we essentially took into consideration the implied penalty and then had a lower increase in year 1 of like a 3-year plan or something like that to make up for the non-compliance? Would that be something that would kind of fit your idea?
Yeah, if I'm understanding you correctly, that sounds good. And what I was suggesting was that we defer the increase until we get documented evidence.
So the first increase would be contingent on an appropriately filed in compliance application that's properly noticed. And then once that is received by the board, with that, we could then grant a 3-year plan to bring the rents from today's X dollars with a 7%, 10%, just the ballpark figures, so that in year T+3, the rents are at, whatever the applicant is asking for.
Exactly. That's exactly what I had in mind. And again, no increase until until the penalty is imposed. So the penalty would be reimbursed the unlawfully increased rent and, whatever else we, want to impose before the increase goes into effect, the incremental increase goes into effect.
May
Yeah.
I ask a question?
Yeah, please.
Is anyone aware of the difference in the rents, like what was supposed to be? Are we aware of those numbers?
Yeah, they're in,
Yeah,
they're
he
in,
actually, oh, go ahead. Yeah.
sorry, they're in the application pack. I have it as page 7, but I'm not sure if we're all looking at the same pack from the meetings.
Because I'm wondering if we could
I have-
work this out this evening instead of postponing again.
Yeah, sorry, my
If anyone
intention,
intends to postpone anything.
yeah,
for
my intention
tonight.
would not be to postpone.
Thank
It
you.
would be to say
Thank
that we're going to make we want to come to a judgment or a recommendation, but it be contingent on him correctly, the applicant correctly filing in compliance, not only with our ordinance, but with that in compliance with New Jersey state law.
Exactly.
'cause that-
So it's not a postponement of the decision, it's a
Right.
postponement of the. increase.
Enforcing, yeah.
Yeah.
Okay. thank
Perfect,
you for
Megan.
clearing
That's
this up.
exactly the page I was looking at.
Wait,
Oh, that's it. That's the page I was looking at too.
Yeah.
It's labeled landlord tenant registration form, property information. Yep.
have it now. Okay, so what I'm trying to discern, and you guys can walk me right through this since you're so well aware of how things are not in compliance. So tell me, with this page here, I'm only looking at the current monthly rent. What I would need to see is the previous rent, I suppose, to determine compliance or lack thereof in terms of increasing rents. Is that what we're looking to see, what was done improperly?
That's my position, yeah. So I think that he purchased, petitioner purchased the property in 2001, I'm sorry, not 2001, 2021. So whatever it was prior to the purchase. And I think that we have the old lease agreement in front of us. Maybe we don't.
Because I don't know how we can make this determination without seeing
I
two
have a
sets of
question
numbers.
while Kabir looks for it. My question is right now, they're paying let's say average, round it's $850. The
Yep.
increase is $650, right? So I would propose that we increase 300 1 year or 325 1 year or whatever it is, and then the rest the following year. I don't agree with 3 years. I think it's way too long.
Yep.
Maybe do a 2-year increase.
Yeah, I have no issue with that.
I agree with you too.
I do as
something
well.
that's fair. 3 years the first year, the next year will be the rest of it. So it's 1,500 even, which, gives them 2 years. And then in terms of what the rent was before, I don't remember when he increased it. If it was recently, I think that he should just give back what the difference is to them. That should be, his penalty is giving it back, and going from there.
I think that's a wonderful
I
idea.
think it's
I think she's right on the point.
fair
Perfect.
to both parties.
Yeah, I'm okay with that as well.
All right. I think I think that's a wonderful idea. So I believe we should,
What is the increase ask? I can't find it right now. It's in.
Yeah, I think
Fif-
go up
Oh,
to
this one.
1,500.
Okay.
Or the 2-bedroom. Yeah, it's 1,500.
Yeah, for all units out exclusive of unit 1, because that's outside of the there's a new tenant in that space, so they're not subject to the ordinance. So for units 2, 3, 4, 5, 6, stated rents of somewhere between $846 and $860 or maybe $883, and it's a little illegible. The proposed increase would be somewhere between $650 and $660.
So what Asmaret is saying is in the 2 years. So right now the current rent is the $850. And
some of them are paying $880. It's
right
average.
around the average around
Mhm.
$850. So the increase would go from $850 to $325 after he's fully complied with the ordinance in the first year, and then the second year an additional $325.
Not 325, it's the difference.
The
to make
difference.
it to 1,500.
Whatever the difference is.
Right, that's
Whatever
what the
the
difference is.
Yeah,
that is what the
it's not.
difference is,
Not
right?
split it into.
Because the rents are different.
Yeah,
it's
it'll be a
not
little bit different than
it'll be a little
325.
different. Some will be higher.
But
some
we're
will be lower.
around, right, but that's what I'm saying. The rents right now, the average is $850.
Yes,
So
so
it's just only like $10, $20
Correct.
difference
Correct.
between the other ones. So it
But it's
is
not exactly.
right is what I'm saying. Estimated around 325 the first year and 325 the second year.
Correct.
I don't necessarily, I feel more comfortable with Kabira's first proposal of 3 years. 325 in a year is very high, and
just
he's
want
still not.
to, that was my suggestion, not Kabira's, just to be clear.
Yeah.
Oh, okay.
That was
Okay.
Anthony's suggestion.
Okay.
Yeah, I mean, I was actually going to
I don't
suggest
know.
5 years, but I'm willing to meet somewhere in the middle and suggest 3 years.
We have to, well, we don't have, we can keep it in mind or not. We've all pretty much agreed that the landlord is enduring a hardship. And even at the $300 increase, guess what? It's still a hardship because
Yeah.
it's well below what the market will bear.
Well below even Section 8, which is 1,700 for a 2-bedroom. So
Exactly.
Well,
I'm looking at the application, and so I'm comparing it to what he's asking and what his monthly expenses are. So he's on the application, monthly expenses is $7,251.90, right? So this increase that he's asking for isn't going to bring him make him break even. It is a profit that he's
Yeah, but there's an investment in there also.
I understand, but I'm just looking at the application. I am making it clear, right?
Just to clarify,
you can't say that because that's an extra $300 times how many units per year to help with this hardship case. He has a hardship case.
and
But that's what I'm saying.
can I just clarify the math? In that first year, he'll still be running at a slight deficit to his expenses. So if we were to approve this 325 increase in year one, his total collectible rents move to 7,227, and his stated expenses are about 7,310. That does include that management fee, which during the deliberation and questioning, that is something that he charges and collects himself. So it's not a cash on cash return. So his net outlay for managing and covering the management fees of the business, there's a slight deficit in year one. He doesn't then go to cash flow positive until what would potentially be year two of this proposal.
Yes, and I understand that, but I'm also concerned because it is far above the 2% that is allowed in our ordinance. It is far above the 10% that is allowed by the state. So that's my concern. It is, even though he is still, at a deficit in the first year, he will be barely breaking even or making a profit in the second year. If we do the 2-year, my concern is it's still implicating or affecting the tenants as well, right? Because if it's, this is a large jump for them as well. And whether or not they are able to maintain that or stay in the unit, whatever, that's something separate and a different concern that I have as well. And I want to make sure that that's also kept in perspective, right? Because if your rent or your mortgage or whatever suddenly increased from $850 to $1,500, that is a hardship as well for the tenant.
So the
I just
compromise, excuse me, I'm sorry, but the compromise is our approach to it. And also, I have to say that given where the rents have stood, many of these tenants have been in the apartments for quite a few years. So they have, in a way, there has been a benefit to them that their rents have remained so far below the market for such a long period of time. It's a hardship on both sides. There's no way to make everything.
I understand that
Well
it is a
said.
hardship on both sides as well, right? But I'm just I just want to make sure that we're taking that into perspective, right? Because yes, it's a hardship now for the tenants that their rent must be increased, right? However, I would argue that they have benefited from this low rent because they are still able to afford. A part of the reason why they've lived in these apartment buildings for such a long time is because their rents are so low. And as everyone has stated, you are not going to find any apartment, a 2-bedroom in Essex County, probably for the rate that they're paying now, which is a part of why they've been able to maintain their residency here. So like I said, 325 is a big jump from one year to the next.
Is there something you'd be comfortable with?
Well, I do like the idea of Kabira's 5-year extension, or longer than the 2 years.
I disagree with that. I think he should go for 2 years.
I think we should just vote on this because
Yes.
the market is only, you know, it could go up, it could go down, but whichever way it goes, the rents being charged are just significantly below even Section 8 numbers, as Maret has brought to our attention more than once.
Esmeralda, could you repeat that figure for the
Sure.
Section 8?
If you go on the West Orange Township website, you'll see under Section 8 that a 2-bedroom goes for $1,700. The tenants are now paying $800. That is unheard of. You can't even pay a 1-bedroom for that much in West Orange. So
Thanks. I just asked. I understand.
I know you
agree.
asked, and then I'm also commenting. So right, so I have that right as a board member to also comment. The landlord has a hardship case, and I think we're being more than fair giving the tenants 2 years. We're not automatically increasing it to $1,500. We're giving them 2 years, $350 the first year, and then whatever the remaining is to get to $1,500. We have to look at it for what it is. He asked for a hardship. He has a hardship case. I think 5 years is ridiculous. It's not fair. He's an investor. He's also a taxpayer, and that's why he purchased it. And I know it's not, I know that for the landlord, for the tenants, that it is an increase, but 300 is a fair amount versus going straight to the 1,500. And we're going to ask them, right? Didn't we discuss that we would ask them the landlord to pay back the increase that he incorrectly, unjustifiably asked them to pay?
So it sort of balances out. It balances out.
Yes,
So
but also
I think we're all on different sides of the spectrum. We should just vote on it because I don't think we're going to agree.
I agree. I think that we should.
Hold on a minute. So I just want to make a correction here, and also I just want to say I think we should all try to be civil because we're all being civil servants here and working hard and not getting paid for what we're doing tonight. So with that being said, the caveat though to the fair market rent is this is the fair market rent for habitable premises. All right. And the tenants, the objectors have testified, some of them, that that their apartments needed repairs. Right. So if we're going to say fair market rent is $1,700, the preface to that and the caveat is that this is the fair market rent for habitable apartments. I don't know what these apartments look like. I did file an Open Public Records Act request for, inspections that were done in the units, things of that sort. I haven't received any response to that request yet. But, my thing is, what if they come back and they say that the premises are deplorable? I don't think that that's the case. But, we don't know that. So
I think we're veering off topic, guys. We're moving.
It's not off topic.
Yeah, I agree. That's not off topic.
The ordinance even makes mention of that the increase should be based on the conditions of the unit. All right.
I agree with that statement. I think, given the testimony from the objectors last month, they didn't raise, at least in my view, and given the visual evidence, there were some deficiencies of the building, right? That doorknob being missing, the discussion about the snakes and rodents in the basement. Again, on testimony, the landlord said that those things have been rectified and I think committed to continuing to maintain the property at a level that would be warranted, and cited the new stove, the plumbing fix that happened in one of the units. So it doesn't sound, in my view, that these are uninhabitable, because had the objectors had that concern, I think they would have raised it during their testimony.
Yeah, I haven't heard, I'm going to be honest, I haven't heard seen any red flags or heard any red flags either. But I just want to make sure that we understand what we're doing when we start making these comparisons by saying, well, it's not fair because apartment down the street is charging $1,700 or $1,800.
Well, it's not.
That
just
would only be
apartments
unfair
down the
if
street.
the apartments were comparable in terms of their habitability, livability, quality, things of that sort. 1,700 may go to an apartment that was built, I don't know, in 2020, you know, that has a brand new stove, you know what I'm saying?
Yeah.
In the conditions of these units don't seem to rise to that level.
I would like to argue that maybe if he had more rent, that now the doorknob, of course, he could fix. But my argument would be if he had more financial resources, certain things would be in better shape instantly.
But
I mean, I
payment
don't know
of
if
rent is not a
anyone-
prerequisite to the warranty of habitability. The landlord has an obligation to maintain habitable premises regardless.
You can
of whether
repeat that
the-
all you want, and I'm going to repeat that if he had more financial resources, other than something like a doorknob, it would probably be easier for him to provide.
I don't know what his I don't think any of us knows what his financial resources is. We don't have
Well,
access.
he
to
did
his
testify. He did testify to the hope of making material capital improvements to the property.
Sounds like he desires to do so.
Now,
Those are capital improvements. Those
so
are not abating uninhabitable conditions.
totally agree. And to no fault of his own, during his testimony, he inadvertently potentially said, when these tenants move out is when I plan to do it, because they have to be vacated, because he wants scale to do all of the properties together. So that's something that, you know, I didn't take into account on the hardship side of things, that the capital improvements would come thereafter. So I do agree. I think it's a very good point, Kabira.
Well, I think he meant when this tenant move out, he's going to do all these repairs, but then he's going to increase rent.
Yeah,
So
to
then he's
25,
gonna
20,
get
yeah.
money.
Exactly.
Then he's going to get his money. So
What the
what
market rate
our
is.
chairman
Mhm.
is saying, she's absolutely correct. If he had the resources, I'm sure he would do it. But I think we should just bring this to a vote.
I do too. I do
Okay,
too.
so let's clarify
I agree.
what's on the table. So
So,
I think so far I don't know that we have consensus around the timeline, but the proposal that we've talked about so far is a 2-year scale, 325 in the first year, the remaining balance in year 2 to bring
Yeah,
the
in 2
apartments all
years.
to 2,500.
So
Into
let's-
it.
Sorry, up to
motion.
1,500.
why don't you make that motion?
I just want to clarify, does anyone have a question about that or any suggestions
I do.
before? Okay, Melinda,
I
go
do,
ahead.
because we have to add that caveat of
That's right.
once as long as he becomes complacent with the
Compliant.
ordinance, compliant with the ordinance. Apologies,
No,
kids are in the background. Compliant with the ordinance and has paid back the penalty, right?
Right. So we'll I guess it'll be a little difficult for us to capture exactly what was overcharged. I think limited because of, one, the lack of history of signed leases that not only the landlord testified to, but the objectors also testified to. So we won't be able to tell exactly when or how much was incorrectly charged or unjustifiably charged. But you know, if it's 2%, we could back our way into a number, assume it's the 12 months that he's had ownership of the building of, and just say flat rate, that we could back that out. Is that something everybody would be okay with?
Yeah, because I think that he did increase it to 2%, so we could, easily do the math,
Yeah,
and
so that's-
determine what the base rent was.
If I recall correctly, though, it was 2% for some and then 3% for others. So just make sure that we are able to capture the correct charges.
So
Because
it's going to be a little
if-
difficult to do it
I think we should just.
perfectly. If we just take round numbers, we'll do 2.5% on an average rent of $850. Are we okay using those numbers?
Absolutely.
Well, hold on. I'm not sure if I'm okay with using that number. If we don't get documented evidence from the tenants or some sort of confirmation that in fact was the number. Because, I think we need to be sure that,
Sorry, what?
I think the tenants are on. Can we ask them? Can we bring them in? And I see Elizabeth Cartagena. I think she's one of the tenants. Or
I don't think so. I think we're done with that, right?
Oh.
Like we have to, this has to be done between us and whatever was collected, right? I'm sorry,
Well, I was
Mr.
gonna
Graziano,
say-
that's correct.
So Kabir, what's your
gonna say
concern?
That it wouldn't be prudent to grant an increase without confirmation of what we're requiring.
So
you know,
what's the concern on what we don't know?
So we don't know how much the increase was. So what I'm going to suggest is that we impose, that penalty, and then we will lift the penalty once we get documented confirmation that he reimbursed the monies from the tenants, and that can be done by them signing off on some certification. Yes, we were, charged 2% and we got that money back to us. You know what I'm saying? Like something to that effect.
I agree. I like that, Kabira. That's a great idea.
Yeah.
May I ask one question? Was the 2% that was charged to the tenants, what was illegal about it exactly? What was inappropriate? I shouldn't say illegal, but what was?
You didn't give him a 30-day notice, right? Is that what it was?
Right.
A written notice.
Yeah, he has to give, he has to give.
And the lease is not compliant with the New Jersey law. The lease is not compliant with the New Jersey law.
In what way?
The,
Missing that section about,
go ahead, Councilman.
Yeah, I don't know exactly what the section is, but it's missing a section that Kabira had brought up.
Let's talk about articulate fully how he's not compliant. Okay, I get that he didn't give notice for increasing the 2%.
Yeah, he didn't give prior written notice prior to imposing the rent increase. There's also a section in the ordinance that requires the lease to have certain language in it. He conceded that the lease didn't have that language in the ordinance in it. I don't remember exactly what, I think it was something about tenant rights, and it was a couple of things in there that the ordinance. Can you guys still hear me? Because my computer.
Yes.
Okay, thank you. My computer keeps freezing, so I apologize for that. But yeah, there's a bunch of terms in here.
Can I have it? I have the ordinance in front of me. So if you go to 15-2.6, notice of tenant's right, it says every lease shall contain a provision in which shall advise the tenant in a conspicuous manner the name and address of the rent leveling board, the maximum rent allowable, the tenant's right to object a proposed rental increase, the tenant's right to a hearing before the rent leveling board if objection is filed within 30 days of notification on any proposed rental increase, and the tenant's right to appeal the findings of the board to the township council. This notice of tenant's right shall be given at the inception of every lease and annually in the case of renewals. In the case of a periodic tenant, the same notice of tenant's right shall be given in the inception at the anniversary of each tenancy.
My question is only, how do we know that this landlord was even aware of this ordinance?
He knew when he purchased the property. He said that that was one of the questions that I asked him when we had the opportunity to ask questions, that he was aware that there was a rent ordinance and that this particular building that he was purchasing was covered under that ordinance.
Okay, all right, okay. Now let's go back. Let's get back on track. So I'd like to make a motion that once again, we vote on two different items. Okay, so the first would be, Anthony, you articulated it best. So can you just reiterate what you said about the 2 years, the increases that are imposed, and then someone can second it? Go.
Yeah, so, and I guess, Melinda, are you okay with us carrying forward? Is there any other concerns?
I don't think so.
Okay. Yeah, so I would make a motion that we would allow the landlord, the applicant, to put in place a 2-year rental increase, $325 in year 1, the remaining balance per each unit to bring them up to $1,500 in year 2, contingent on his ability to file a application that is in compliance with the West Orange Rent Leveling Board ordinance.
I second that.
And giving back, right, the difference as well.
Correct. Yeah.
as well.
So to continue that, and prior to enacting any increase, have signed affidavit from tenant and landlord clarifying any increase previously charged and taking that balance and then netting it against the new proposed increase. So essentially giving them a credit for money that they were unjustly charged and have it be applied to their now new lease and new new rent going forward. So for
Y'all
example,
agree with the credit?
I'd like to say that we put Anthony had earlier articulated that we rounded out to 2.5% percent. So I make a motion that that credit, I don't know how to articulate it clearly, but because there's no way to definitively calculate what was overcharged, what was, that we just round off the number like Anthony suggested.
And Deirdre, are you basing that on the testimony that the, both sides, tenant and landlord, said that there was a 2.5% increase? Like, what are you basing that on?
I'm basing it on both things. I'm basing it on the testimony because some people were increased at 2.5%. Some people were increased at 3%. Some people were increased at 2%. So I liked Anthony's proposal that just a credit based on 2.5%.
I'm sorry, Deidre. I disagree with that. It should be exactly what they were overcharged. So if it was 2.5% for one tenant, then they need to get that back. We should have rounded.
Calculate that, guys. With all
didn't in his application, didn't he have the original rent in one of the applications?
I think he did. And also he knows what he charged them and the tenants know what they were charged. So that's why they're signing a certification.
Okay, then we'll credit them based upon the documentation. Okay, so let's start all over. So.
Okay, so
I hugely apologize, not trying to prolong, but I'm more comfortable with 3 years rather than 2 years. So how do we rectify that? Because I don't want to give a straight up no.
Because we're going to take a vote. I'm going to make a motion that we impose a rent increase with $325 for the first year, and then going up to the $1,500 for the second year. All I want to know is who is in favor of the 2-year agreement?
I am.
I
am.
Can we do it the show of hands?
Let's do a show of hands in the screen because I can't really see it. So who's all?
There's no stipulation now, though. You're agreeing to, you know what I mean? Like,
well, ladies and gentlemen, can we get back to parliamentary procedure here? Okay.
Yes.
Madam Chairwoman made a motion. Okay. And by the way, while we're making motions here, let's keep it to one motion. The thing that we were talking, I think the last motion that was attempted to be made contained at least 5 or 6. I kind of lost count in all of the excitement.
Okay.
But anyway, Chairwoman Saunders has a motion out there. Does anybody have a second to Chairwoman Saunders' motion?
I will second that motion.
I do. I second.
Okay. So does anybody have any discussion that they want to make before you take your vote?
I do not.
No.
No.
Okay, so Madam Chairwoman, proceed to call the vote.
Okay, now, thank you so much for getting us back on track. I'd like to make a vote that we impose a rental increase over a 2-year period. For the first year, we increase the rent to $325. The second year, we come full to the $1,500. Going to stop right there.
All right, so that's your motion.
That is
anybody
my motion.
Anybody seconding that motion? Mr. Campagna, you can second it again if you want. Okay.
I second that motion.
Okay, so now vote.
Now I thank you so much.
I vote.
Okay, so
all in favor, all against?
Who's in favor?
I am.
I am. So that's 1, 2, 3, 4.
Madam Chair, if it's permissible, how about I just do a roll call on the votes this way we can.
Beautiful. Thank you, Peter.
Okay, thank you. Okay. Board Member Rodriguez?
Yes, I vote yes. I'm in favor.
Board Member Myers?
I vote no because of the short length. I think it should be extended. So my vote is no.
Board Member Geber-Michael?
I vote yes.
Board Member Huerta?
no.
Vice Chair Anthony Campagna,
I vote yes.
Chairwoman Sanders.
I vote yes.
Madam Chair, that's a vote of 4-2 in the affirmative.
Okay, so let's make our second motion.
So yeah, I'll make a motion that the applicant repay each of the tenants the exact amount they were overcharged on their previous rent that was not in compliance with our ordinance.
I second that motion.
Okay, Peter, take it away. If you would just ask us one by one.
Bear with me 1 second. I'm writing this all down.
Oh, thank you.
One second, I
I'm sorry,
apologize.
Peter. I'm so sorry. Sorry.
It just, so upon compliance with the ordinance, correction will at least provide a proof of payment. The landlord will repay. Is that correct? This is the ordinance, this is the motion we're putting forward, correct?
Yes, correct.
Okay. That was by Vice Chair Campagna and seconded by everyone. Okay, Board Member Rodriguez.
Yes.
Board Member Myers.
Yes.
Board Member Gabriel Michael.
Yes.
Board Member Huerta.
Yes.
Vice Chair Campagna.
Yes.
Chair Sanders. Chairwoman
Yes.
Madam Chair, it's unanimous, motion carries.
Ladies and gentlemen, may I interject? In fairness to the applicant, I think we should be a little more clear about what he is compelled to reimburse to the tenants, a dollar amount or a formula if possible.
Yeah, so to clarify, that would be the percentage increase of rent that was imposed during his ownership of the building from when he, I guess, do we know the date that he took ownership of the building? Because we can say from that date till his application is in compliance.
Or how about when the increase was imposed? So if whenever the increase was imposed, you multiply that times however many months the increase was in effect. So if it was imposed in January of last year and it lasted until today's date, then that's the amount of time, you guys see what I'm.
Yeah. So to clarify, the amount to be reimbursed represents the percentage increase when it was applied up until the applicant becomes in compliance through his application. So for each apartment, it'll be a different dollar value. Given the testimony we've heard, it's somewhere between 2 and 3% of the total net rent per unit. And again, given the testimony that we've heard, it's somewhere in the range of 10 to 12 months. Does that clarify enough, Alex?
I think so.
Yeah.
But if I'm trying to frame my question here. So if a tenant was paying $800, let's say a month, and applicant increased the rent to $1,500, he would have to reimburse the difference between the 800 and the 1,500?
Yes, correct.
10 months?
Yeah, so in the instances of these apartments, it appears to be somewhere in the range of about $20 per month. From $850, a 2% increase would be around $20 per month. Across 12 months, it's about $250 in total.
Okay.
So I think with those two motions we just passed, we've clarified what we've approved and what should be reimbursed. The one issue that I think we still need a motion for is those two will not happen until there's a application filed in compliance with not only the West Orange ordinance, but the state of New Jersey ordinance.
Well, when you say, Mr. Campagna, an application filed, I think, do you mean proof that the landlord supplies to the board that he is in compliance? He doesn't have to reapply for another hardship application, right?
Correct. Yes, that's correct. Yeah. Kabira agreed. Melinda agreed.
Yes.
Yeah.
Yeah.
Okay.
So so the penalty gets paid. We get evidence of that from both landlord and tenant. And I'm trying to think of what the other thing was. So if we're talking about demonstrating compliance, then are we talking about reissuing the lease?
So I would say,
agreement?
yeah, there has to be a new lease agreement put in place as well.
Yeah.
Yeah.
Because that would be compliance.
Yeah, so to include the proper language, to include the now agreed upon new rents.
Yep.
You know, I'd say in
And
a
the
perfect
proper
world.
prior notice as well.
Correct, yeah, so in a 30-day compliance, so all the things that are written in section 15, that the applicant updates his application, not resubmitting a new application, but contingent on those updates being submitted to the board, then the two motions we just passed can be enacted.
Or may I suggest, members of
please.
the board, that maybe the landlord just supplies an affidavit saying, this is what I've done to bring myself in compliance, A, B, C, D.
That's even better.
That's
Yeah.
a wonderful idea.
Isn't that self-serving though? Without any documented evidence?
Well, what kind of evidence would you suggest that the landlord supply, Ms. Myers? I mean,
I would like to see.
I mean, you're talking about he's going to make an affidavit. He's taken an oath. I mean, is he going to commit perjury just to get over on us?
I don't know. No disrespect, Mr. To the applicant. But I mean, why not just show us what he's done? I don't think it's that hard. If
Well,
he's serving.
all right. Let's focus in on the phrase, show us what he's done. How does he show us?
I was going to get to that. So how about giving us a copy of the 30-day notice that he served on the tenants? How about giving us a copy of the new lease agreement that he's served on the tenants?
Would
I
would
think
today's
that's a
application already wouldn't the application that he's put in front of us already suffice the 30-day notice, given he did the notice of these meetings with the intent of increasing the rent?
No, the New Jersey law is clear on what the prior notice must look like. And it must terminate well, anyway, I'm not going to go into all of that.
Okay.
Yeah. And maybe he needs to consult with a lawyer beforehand, or just look at the statutes and the case law as to how to properly do that. Or Ellison J's Tenants' Rights Manual, which is actually on our website. Legal Services of New Jersey's Tenants' Rights Manual is on the Rent Leveling Board website. It talks about how to properly increase the rent in the state of New Jersey.
Okay, so this final motion would be, Kabir, are you comfortable with an affidavit of his compliance as opposed to the show it? I mean, it would be him purging himself.
An
if he
affidavit.
weren't.
How about an affidavit with exhibits attached? That could be
Right.
that could be done too.
I'm good with that. I like that, Mr.
All right.
Graziano.
So let's keep the ball rolling. Let's not stop the ball.
Final motion for me tonight, hopefully. I motion that the applicant provide an affidavit with exhibits to show how he's brought his current application to compliance, at which point the prior two motions would be able to be enacted.
Yep, I second that.
Excuse me, I'd like to make one comment. Can there be a deadline associated with this? This should not be going on into perpetuity. Our goal is to make sure that this issue is resolved. So can the applicant have like 30 days to get himself in compliance?
That would fall under his responsibility. I'm sorry. That would not be our fault or our responsibility.
Couldn't we impose a deadline associated with the compliance?
I mean, if he's not in compliance, he can't charge new rents.
Right, he
so
can't get the increase.
Yeah, his best interests are to do this as quickly as possible.
Okay.
Yeah, and to be in compliance, it would be at minimum 30 days, meaning he'd have to show that he's noticed the current tenants that the proposed increases. But if we just want to put a tail on it, we could say before the end of the year.
Yeah. I see Deirdre shaking her head because I certainly don't want to be, working on this, till the end of the year either. But again,
okay,
I agree with what was just said, though, that if the landlord wants those increases, then it is in his best interest to work with speed. And at a bare minimum, he's required to wait 30 days before he can get that increase. If, for example, he served the 30-day notice today.
Okay, so can we give him, let's say 90 days?
I mean, I don't even know.
Or say minimum, or say minimum of 30 days. I don't know. I don't even know if we
have to, though, because again, it's on him. He's the one who wants the relief. You know what I'm saying? And he can't get the relief until he's shown compliance, and the increase can't go into effect until after the 30-day, until, 30 days after the, you know what I'm saying? The notice, that whole good thing. You
So
know,
then I would say that we're.
expiration of lease also.
Yes, I agree with you, Kabira.
Okay, so we'll carry the motion for a vote.
Yes, so what are we?
Mr. Capani, for the record, can you please state that again, the motion, so it's
Amen.
have for the record correctly?
Yeah, so I'll make a motion that the applicant provide an affidavit with, what are they called? Exhibits included to show his ability to bring the current application in compliance with the ordinance.
Hold on, I'm so sorry.
Okay.
So the only thing that I'm concerned with though is that, so New Jersey law requires the lease to expire prior to imposing the increase. So the increase cannot go into effect until the landlord serves notice of termination. And 30-day notice of termination. And again, the increase cannot go into effect until that happens. So I don't recall the term of these lease agreements.
They're all month to month.
I think they're month to month.
Okay, okay, they're all month to month, all right.
Yeah.
And then also, I just want to tweak the language a little bit, Anthony.
Yep.
Shows that he can comply. I think that he must comply. So he must show compliance.
Okay.
Why don't you make the motion, Kabira?
Yeah, go for it.
Holy Lord.
You're already there. You're already there. Go ahead. Keep the ball rolling.
Oh, yeesh. All right. I'm gonna try to remember everything. So I make a motion that in order for the landlord to receive the rent increase that he's requested, he must show documented compliance with New Jersey law by issuing to the board a certification that attaches exhibits documenting and proving said compliance. And the compliance that must be demonstrated is proper notice prior to the rent increase, as well as proper written lease agreements issued to the tenants. And I think that's it, right? It's just those two things.
Yep.
All
I
right.
second.
Excuse me, is this all not in the ordinance, or I'm curious? Everything that he's required to do is articulated in that ordinance, correct?
That's correct. Yeah.
Yes.
So long story short, I think we sort of got it, because he's gonna have to go to the ordinance, provide the affidavit, provide evidence.
Great. Yeah, let's carry the vote.
And so there's nothing more that really needs to be said, I think. I'm pretty sure.
There was a motion and there was a second.
Second it, yep.
Mhm.
And now we can bring it to the vote.
On the motion by Ms. Myers, I'm not gonna repeat it, I have to grab it off the internet again. And second by board member Geber Michael.
Yes.
Okay. Board member Rodriguez,
Yes.
board member Myers,
Yes.
board member Geber Michael,
Yes.
board member Huerta,
Yes.
vice chair Campagna,
Yes.
Madam Chair Sanders.
Yes,
Madam Chair, the motion carries unanimous.
okay. Now, correct me if I'm wrong, but are there any other matters that we need to discuss this evening?
I think just public comment.
No, we were just, should we, does the public get to comment this evening?
We just have normal public comment, not on the application.
It's
I mean,
on
they
the
could
agenda.
make comment about the application, but it's not something that we would discuss thereafter.
So should I just?
Yeah, you can
the
open
floor?
public comment. Yeah.
I'm gonna open the floor to public comment then. Does anybody have anything they wish to say?
Please raise your hand and state your name and address for the record.
Okay.
I'm not seeing any. Let's just give her another minute. We have one attendee. Let's give her the opportunity to say something. Okay, I think no hands.
Okay, then I'm going to make a motion to adjourn this evening's meeting.
I'll second that.
Okay,
All those in favor?
Aye.
Any opposed? Seeing none, motion carries.
Have a good
Thanks,
night,
everybody.
everyone.
Good night, everyone.
Well done, good
Well
evening.
done.
You did it.